SJC-13736 in the matter of an impounded case.
Okay, Attorney Daniels, whenever you're ready.
Thank you. Good morning, and may it please the court. Attorney Josh Daniels for Doe number 527962. I plan to focus mostly on factor 37 this morning, and my main takeaway here is that there is no meaningful difference, I don't think, between how the board is currently applying factor 37 in these cases and the unconstitutional way that it used to apply the former version of its factor 2. Under both of those factors, essentially what the board has been doing is relying on repeated sex offenses that take place before the sex offender is apprehended or caught to make a prediction about the offender's future sex offending behavior. Under factor 2, it was risk of reoffense. Now it is dangerousness. The problem in both circumstances is, and the board doesn't really dispute this, they didn't before and I don't hear them to be doing so now, is that there is no scientific or empirical validation that this kind of conduct is predictive of anything. That is why the former version of factor 2 was mostly struck down as a due process violation, and I think everyone agrees that that was the right decision.
Down because of the compulsive aspect of it. Our earlier decision said repetitive is different from compulsive. Compulsive is an additional requirement. So I don't know how far that gets you. So multiple offenses, the statute refers to the number of offenses as something that you're supposed to consider. So how do we go beyond that?
I mean, I think as I read Judge Wilkins's decision,
Judge Wilkins is, with all due respect, we've interpreted him. So why don't you focus on what we've done?
Right. I mean, I think ultimately this gets back to the problem of scientific validation as a requirement for anything that the board considers. So as this court held, I think, in 205-614, or at least that's how I read that decision. The board has an obligation to ensure that its guidelines are grounded in objective facts and data and empirically validated science. And this is necessary to ensure the due process right of the individualized nature of the hearing. I think stepping back.
Excuse me, is that, I'm not as conversant with the numbers but as you are, but is that the gender-based case?
Yes.
So in that case, it's importantly different because there, the person sought to introduce evidence that women were less likely to recidivate or less likely to be dangerous or both. And that's not the situation here, right? This is not a situation where SORB has refused to consider evidence.
Right. I am going a little bit beyond the situation in that case. I'm relying on the language at pages 608 and 609 of the court's decision that talks about the importance of what the board is considering being grounded in science. And I think that is required by due process because
But they also have to follow the statute, right? And the statute expressly tells them to consider the number of offenses. And there's no other, but correct me if I'm wrong, it doesn't appear that there's any other factor in the regs that directly corresponds to number of offenses. There's number of victims, but that's different.
I think that's right. There isn't a complete overlap between factor 22, which is number of victims, and number of offenses. I still think as a matter of due process, one aspect of due process is that it needs to be a process that is reasonably calculated to ensure accurate determinations. The government has an interest in classifying offenders accurately, in making sure that they're not underclassified, as well as, and the offender has an interest in making sure that the offender is not overclassified. So I think whatever the government considers, irrespective of what the statute says, due process still comes in as a sort of background matter and says it has to be based on relevant considerations, and I understood what this court said in 205-614 as basically saying as like, the relevant, you know that it's a relevant consideration and thus helpful to achieving an accurate determination if it is grounded in science.
So is there no role at all for common sense in the sense of, dangerousness is supposed to go to the harm that is posed by a particular offender, and if a particular offender not only has multiple victims, but the course of that offender's conduct is that they tend to repeatedly offend against the victims that they do have, doesn't that indicate greater harm in a way that could at least be considered as a factor, even if I recognize it was deemed a high-risk factor here, but at least could be a factor?
So I'd like to take that in two parts. First, as to common sense, I think if we have learned anything from the saga of Factor 2, it is that, and from SORB jurisprudence generally, it is that common sense is a very sort of dangerous guide in this area because there is a lot about the nature of sex offending behavior that is counterintuitive. In the Factor 2 litigation, as you might recall, Dr. Hansen himself described his findings about the sort of lack of relevance of number of offenses before apprehension as a surprising finding.
But again, Hansen, and do we have Hansen's commentary? I remember the last time we did this, we sent it back and Hansen said, you can't find compulsive unless there's been an apprehension or some kind of conviction in between. And then there's a statement, there are no findings, and that's the troubling part for at least Mr. Chanel, is that statement. But was he talking about in context of compulsiveness, meaning sort of a medical concept, or what was he saying when there's no correlation? And do we have that? Because that's going to be important. Do we have the subsequent testimony from Hansen about that?
I believe everything we have from Dr. Hansen can be found in the CPCS amicus. And as I understood Dr. Hansen's testimony, both in the prior Factor 2 litigation and what he's saying in his current letter that CPCS included in their amicus brief, what I understand him to be saying is that if you have somebody who has repeated offenses before they are apprehended and before the criminal justice system has imposed a legal sanction on them, that person is statistically no more likely to reoffend, and statistically there's no reason to think that they pose a greater risk or danger based on simply the number of offenses that are in the so-called index cluster, the universe of offenses that they commit before apprehension.
Well, doesn't he actually say that there has been no study of the latter? That he has concluded that there's no correlation absent, being caught, apprehended, between repetitive conduct and likelihood of reoffense. But as to dangerousness, I read the letter, which I take it the hearing examiner didn't have.
Correct.
But I read the letter to be obscure on the issue of dangerousness, and I'm wondering what we do on that.
Right. What he says is there are no studies on this subject. That is correct. I think still it is, as I see it, that's a problem for the board because what they consider has to be scientifically validated, is my position. I'd like to get back to the second part of Justice Stewart's question.
That's right, but Justice Stewart's second part is, don't they have to deal with the statute? And the statute says, take into account the number of offenses.
Well, part of my answer to that is that due process has to trump the statute, but I'd like to answer it in a different way, which is, as I understand the board's position, at bottom, I think their logic that they're using here under the rubric of dangerousness, when you scratch the surface of it, it is actually no different than the logic they were using for repetitive and compulsive under Factor 2. What they are saying, as far as I understand them, is that if you have a sex offender who has repeated crimes before they're caught, that person is more dangerous in the sense that if they reoffend, they'll do so repeatedly. I think that's just a...
More precisely, though, under the old structure that was struck down, it was a high factor, right? It had a particular nomenclature associated, meaning it was a powerful factor.
Yes.
This doesn't have that, right? This is
Well-
just, it's something to consider.
Well, as the hearing examiner applied it here, he applied it the same way.
I reread it this morning, because I read your brief. Where in the hearing examiner does he say it's a sort of a high-powered factor? Does he, that would be
The
helpful.
way his decision is structured, he goes through all of the factors that he applies, and among the portion of his decision that discusses high-risk factors, he discusses two.
I thought
One
he
is
talks
factor
ab-
3 and one is factor
I
37.
thought he does discuss 3 as a high risk, but then the next discussion is about this, but he doesn't say it's a high-risk factor.
But
does
it's
he?
under the heading of high-risk factors, and then he has a heading that says risk-elevating factors, and then he has a heading that says risk-mitigating factors. As I read the decision, he included this as a high-risk factor, presumably because factor 2 used to be. And I think the natural inference is that in his mind, this is the new substitute, since we can't use factor 2 this way anymore. To get back to what I understand the board's position to be, I take the board as simply saying that a sex offender with repeated sex crimes before apprehension is more likely to commit more such crimes in the future. That's what, he's more dangerous because he'll offend repeatedly. That's what I take them to be saying. They're not speaking in terms of, oh, well, we think if he reoffends, he'll commit more serious offenses in the future. They don't seem to be saying that. They just seem to be saying, well, past his prologue, he was repetitive before. Now he's caught, he'll be repetitive again.
But isn't part of what they're supposed to do in considering dangerousness, this whole idea of past is prologue, right? And so this particular offender's, the two victims here, each involved in situations where he repeatedly targeted those victims. And so, if they're trying to think about what could happen in the future, isn't it rational to think that it would be a similar course of conduct with respect to future victims?
Well, it seems intuitive. I don't think it's rational in the sense that one of the things that the research, I think, shows is about the nature of recidivism is that once you have that intervention by the criminal justice system, that official sanction that signals actually, no, this is antisocial behavior and it's wrong, we can't be sure that we can't be as sure that if they reoffend in the future, it's going that the same will follow. We're making that assumption for purposes of the dangerous analysis because we've disaggregated the two components of any risk analysis that you would do for like insurance or whatever. One component is the likelihood or probability that the bad thing will happen, and the other is the expected severity of the bad thing if it does happen, whether that bad thing is a hurricane or a sex offense. And I think the board, in the way that they're talking about dangerousness, is kind of conflating them together in a way without really saying so. What they seem to be saying is, well, he offended a lot repeatedly before he was caught, and if he does it again, he'll offend repeatedly again. Maybe it's just me, but I see that as not really any meaningfully different from the argument that they were making under Factor 2 about why they could consider repeated episodes before apprehension when they had time to reflect in between. It was they committed a bunch of repeated sex offenses. There was a greater likelihood that they'll commit more sex offenses in the future. We're back to the same thing. At the end of the day,
Really? When in level, the second, in order for the internet posting to go up, we have to sort of identify why we're internet posting. And they say, okay, he's targeted 14-year-old girls twice. He's 22 now, so he's still a young person. So, and he targeted them when he was 18. So it's not relevant that he had multiple victims who were 14 years old when he was 18 years old, and he's still
I want to be very clear about what I am saying. I am not saying that they cannot consider the nature of his offending conduct in terms of dangerousness. What I am saying is that the fact that he committed multiple crimes in his index cluster before he was detected or caught should not count for extra weight beyond what you get from the nature of the past crimes himself. To put it a little more concretely,
he had 50 of them If he'd had 50 of these?
From the perspective of dangerousness, specifically, because that is what we're purportedly dealing with, I think the way that this court defines dangerousness is purely as a function of the amount of physical contact that is either used or threatened, the amount of physical contact you expect or fear will happen in the case of a future offense. So if you have two rapists who are both caught, or two subway gropers, whatever the nature of the crime is, and you have one who's caught after the first offense and the other who's caught after the fourth or fifth offense, I think as 496501 uses the term dangerousness and defines it as a term of art, that it's only about the nature of the crime you would expect to happen in the future, they should present exactly the same dangerousness. They're both rapists, they're both subway gropers. That is the crime that you expect. I don't think it creates added weight on the dangerousness side, simply that there's more offenses in their index cluster. And at the bottom of this case, my point is that the only thing that I see as different from the old Factor 2 litigation is that instead of Factor 2, they're now saying Factor 37, and instead of risk of reoffense, they're now saying dangerousness. And I don't see why either of those things, or both of them, should make a difference. The answer should be the same in this case as it was in the prior Factor 2 litigation. We'd ask that you vacate the hearing examiner's decision, and if there are no other questions, thank you.
Okay, thank you. Attorney Shanai.
Thank you, Chief Justice Budd, Associate Justice, if it pleases the court. Thank you for inviting me back to argue another case. I want to start by saying that really what this comes down to is the analysis of danger. Interestingly, if you look at all the research, especially Dr. Hansen, they basically, when they do the studies, they base danger on risk. If someone poses a high risk, they then consider them to be a high danger. But as you know, the legislature and this court and the regulations have separated danger and risk of reoffense. So the board needs the tools to determine dangerousness. And again, there's a lot of indications that can show dangerousness. Now, Factor 37 being used in this way clearly takes a common sense approach that if someone commits repetitive sex offending behavior, he probably poses more danger than an individual who only commits one sex offense in his life.
That seems to make a lot of sense as common sense. But what do we do with Hansen's? I have no trouble separating out the compulsiveness. That's a medical type of terminology. But what I'm struggling with is when Hansen says that the number of offenses doesn't matter. It doesn't increase the likelihood of the person reoffending. Just to me, I have to reread what he's actually said. But that's the thing that's the most bothersome. So how do we deal with that?
Well,
do we ignore it, or do we distinguish it based on the fact that they just haven't done the science yet? I'm trying to figure out what we do with the science here.
The reality is that Dr. Hansen has always said cluster offending does not cause an absolute rise in risk just based on the fact it was cluster. But the difference here is we're not saying that because it's repetitive, his risk is increased. The hearing examiner never said his risk was increased because of it. What he said was he considers the repetitive sex offending as it applies to dangerousness. And again, he doesn't say it proves that this individual poses a high danger. He said he considered it. And if you look at his discussion of danger, he adds it, Factor 37, with a number of other factors to show dangerous. He didn't highlight that as the main factor to prove he's dangerous. All the board is saying in this case, as you're doing a qualitative analysis to determine an offender's future dangerousness, and again, DOE 49650 is looking at future dangerousness, we have to consider the type of offending behavior that he has done in the past to make that determination. And again, if you look at Hansen, if you look at the studies, there are no real definitive studies that say that individual danger issues they don't focus on that. They focus on risk And then they assume that the danger matches the risk. If you're a high risk, you're a high danger. That's why in the very beginning, in 2004, when the board's regulations, which I had to defend many times, they basically said high risk equals high danger, and then the internet issue. And they didn't separate it. That's what DOE 49651 said. Wait a minute, you can't just say because he's a high risk, he's a high danger. But that's what the research basically was based on. Now, Dr. Hansen, again, looking at his research, will say, okay, this individual, and again, a lot of what his studies show is, sure, the majority of sex offenders are in a certain grouping, but there are the ones that are in a higher grouping, and his research is designed to try to find those higher groupings. And what the board's regulations and the statutory construct is for us to help us find that by using either factors or, and now that we've separated risk and danger, looking at the sex offending behavior to see if that shows an increased danger.
Oh, sorry.
Go ahead.
In my head, what I hear you saying is we are not going to find any empirical, either evidence, studies, or expert statements for the notion that the repetition of behavior is a factor in dangerousness.
Well, I have a twofold answer to that. The first is, even in Dr. Hansen's letter, he said there's no studies on the dangerous aspect of it. The second part of that is, looking at factor 37, I think the whole construct is designed for a hearing examiner to get all the information so that he can make an accurate and fair classification, whether that's information that increases risk and danger or information that lowers it. For example,
But if there are no studies, I agree with that interpretation of factor 37. If there are no studies, which is, I appreciate your frankness on that, then is the hearing examiner, when considering everything in the totality under under 37, relying on solely common sense? What are they relying on?
I think they're relying on the language of DOE 946501, which is the past's prologue, and the sex offending behavior of the past is indicative of the future harm he could cause if he reoffends. Because we know the manner, like in this case, he had two 14-year-old girls, repetitive or at least multiple sexual assaults against them. We know that if he reoffends in the future, that's a possibility. You look at, again, factor 31 is a good example. Factor 31 says if a sex offender has a debilitating illness that may impact his risk or danger, the hearing examiner should consider that. There's no scientific evidence or scientific studies underlying that factor. It's a common sense approach that the board took on that, which is if someone has a debilitating illness, it possibly can lower their risk or danger. But again, there's no empirical study that says that.
Can I ask you one question? Do you concede that it was error for the hearing examiner when laying out the various factors that applied here on page 10 of the hearing examiner decision to put factor 37 under the category of high-risk factors?
Well, first of all, he didn't put it under the category of high-risk factors. He wrote high-risk factor, number 3. I think what he did is he didn't consider factor 37 as in the risk-elevating category. I think he separated it because it was specifically for one issue, the consideration of danger. I don't think the hearing examiner meant to say this is also a high-risk factor, because it's not. High-risk factors are statutory high-risk factors, and it's 1 through 6. And this hearing examiner has been around long enough to know that you can't make 37 a high-risk factor.
But this makes it very strange because he then skips around, right? Because it's like factor 3, high-risk factor, I agree with you, it's singular, high-risk factor, factor 3, factor 37, and then next goes on to risk-elevating factors. So, and then risk-mitigating factors. So it completely is out of place in the.
If I had written it, I would have put it at the end, but he put it in the middle. I think he was trying to separate it from high-risk factor and the risk-elevating factors. And again, I think that in his mind, he was looking at it and thinking, again, I wasn't the one who wrote this, but I think what he was thinking is, this goes specifically to danger. It's not a risk elevating factor in that sense. So I think he was separating it.
But you're saying it's not a risk elevating factor with respect to dangerousness? I thought your whole argument was that it is a risk elevating factor with respect to dangerousness.
I think because of DOE 945601, I think the hearing examiners are trying to separate danger issues from risk elevating issues. And I think that's what he was trying to do.
Risk of
here.
reoffense.
Right, and I think that that's was inexpertly done, but I don't think he ever intended anyone to consider that, or that he intended it to be a high-risk factor, because he never mentions it either in the risk to reoffend or the discussion of dangerousness, never mentions that as that was a high-risk factor. In fact, in the discussion about dangerousness, he just lumps it in with the other three factors that he considered as danger-elevating factors.
So he has to consider it by, the statute says he has to consider the number.
Correct.
The science says that we don't have any proven correlation, at least on risk offense. The science hasn't been done on dangerousness, or although Hansen suggests if it doesn't affect reoffense, it shouldn't affect. So I'm just trying to figure out if we issue a decision saying you can consider it, it can be considered because it's required by statute, but it should be addressed with caution because there's no scientific evidence supporting it yet. I'm trying to figure out how this writes, if we write it in favor of this, because it's messy.
It is messy, and unfortunately, a lot of the SORB law is messy. I mean, we've been going back and forth on this, at least since 2006, and I think I'm going to be starting the defense of my third set of regulations before I retire. Not that I want to, but that's what we're doing.
Speaking of the new regulations, which obviously the briefing doesn't address because they only came out last week or whenever it was, they talk about number of offenses with respect to both dangerousness and risk of reoffense, correct?
Truthfully, I haven't actually read them fully through.
For factor two.
I don't want to make a statement to one way or the other. I know I'm scheduled to do a training soon, so I'll be up to speed the next time, but I don't know the answer to that specifically.
But you would agree that we just apply the regulations as they existed at the time?
Correct, and that's what we're dealing with right now. I'm not sure if the new regulations have dealt with this issue. My sense is it probably hasn't dealt with the way we would want to, because the regulations themselves were actually promulgated a couple of years ago, and it's taken almost 2.5 years to get through the whole process. So, I can't validate what's in there or what's not in there, and more importantly, whether it's even specific to what we're dealing with today. And again, the issue becomes, and I think back to Justice Caffrey, your question is, I think that you have to look at these as a case-by-case analysis. If I think someone who commits just 2 sex offenses against 2 individuals, that's not necessarily looking at the dangerousness, because you've got multiple factor 22. But if you have a situation, which I had, where the individual committed his first sex offense at age 30 and then 25 years later does it again, then you can say, well, wait a minute, he's an outlier. He should have been in these years being reduced by his offense-free time and by his age. So there are circumstances where that could be now something to consider. Again, we're trying to consider the dangerousness as required by both statute and by this court and by the regulations, and trying to do it in a reasonable way. And I think that, again, looking at the way the structure of the whole process is, and it's always been my belief, a qualitative analysis really requires the hearing examiner to look at all of the factors, both those that reduce risk and danger, those that increase risk and danger. And I think that the offender's brief in this matter wants to restrict that to just using 37 to consider those factors that benefit the offender. And that's not a qualitative analysis. The only way we can get to a fair and reasonable classification is if the hearing examiner has all the information in front of him and then can make a reasoned determination. Not if we leave some information out, whether it's helpful or hurtful to the hearing or to the offender during the analysis. And that's essentially the
Counsel,
board's
which
position.
factors lack scientific backing?
Factor 31 and factor 5. Factor 5 is the declared sexually dangerous person and committed to civil commitment. Again, that's a statutory requirement. The only one that doesn't have specific scientific articles that the board created was factor 31, which again was based loosely on what the legislature has asked them to do.
31, what is it described by? It's debilitating.
It's a physical condition, and any offender who provides information that shows that they suffer from a physical condition that impacts their risk to reoffend and level of dangerousness, the hearing examiner shall consider that.
I have a question about the relationship between repetitive behavior, as used by the hearing examiner here, and the number of victims. They're not the same, correct?
Correct.
So it's, what, act by act, episode by episode? What's the quantum of measurement?
I think the quantum of measurement, it's again, you're basing it on the background of what harm this individual could cause should he reoffend, and using the past as prologue. In this case, you got a situation where the individual sexually assaulted one girl when she was 13 and 14 years old multiple times, and then raped a second girl, her friend. And I think you put those together and you can show if prologue is the standard that we're using, then and I think the hearing examiner talks about it a little bit in their internet publication section.
The second one was once?
Well, there was 2 incidents where he committed an indecent assault and battery against her, and then later
Yeah.
raped her.
So I just wanted to, is the quantum of measurement episode by episode?
I think it's the aggregate of episodes. Again, if you have someone who commits 2 sex
So if you have
offenses,
one victim and multiple episodes, that would be repetitious behavior?
yes, and I think that you look at, and I think the backdrop of this is Commonwealth versus King, which I cited in my brief, which specifically this court said that victims of sex offense suffer trauma. The idea being if you do multiple sex offenses against the same victim, you are traumatizing them over and over again. So there's a larger harm that could be caused by that type of offending behavior than someone who commits one sex offense. Now, I'm not saying that one sex offense is not emotionally debilitating for the victim, but we're not looking at that. We're looking at the harm, the extent of the harm that an individual could cause if they reoffend in the manner that they have in the past. And if they continue to repeatedly sex offense against one individual, they're causing that individual much more harm, and a future victim would suffer the same type of harm.
Okay.
So unless there's any other questions, I'd be more than happy to rest on my brief in what possibly may be my last appearance here.